But it has to be over 6. Otherwise, I gotta go for 10.
All rise. Fifth District Court for the County Clare is now in session. Allow Roy G. Mink presiding.
You may be seated. In the case of the People versus William Rydell Yates, counsel identify for the record, please.
Morning, I'm Mark Webb on behalf of the people.
And please, the court, Scott Moore for the defense.
You are William Rydell Yates?
Yes, sir.
Previously, you appeared in court and made pleas to 3 charges. One was assault with a dangerous weapon. A felony carries a maximum penalty of 4 years in prison. One was malicious destruction of personal property of $200 or more, but less than $1,000. A misdemeanor carries the penalty of 1 year in the county jail. And the charge of assault or assault and battery, a misdemeanor carries a maximum penalty of 93 days in jail. Pre-sentence investigation report has been prepared. Sentencing guidelines have been determined to be 2 to 17 months. Mr. Moore, have you had an opportunity to review that pre-sentence investigation report with your client?
We have nothing of factual nature to add to the contradict. Thank you.
Any challenges to the scoring of the guidelines?
Oh, yeah.
Mr. Webb, on behalf of the people, anything regarding the report?
Thank you, Your Honor. I'm sorry. I've reviewed the report. I have no additions or corrections to make to it, and the guidelines are correct.
Mr. Yates, is there anything you wish to say to the court before the court passes sentence?
What, sir?
Is there anything you wish to say to the court before the court passes sentence?
No, sir.
Mr. Moore, on behalf of your client?
Thank you, Your Honor. We do ask the court to follow the recommendation as well as the plea agreement and assign the client to home youthful trainee status. He's had a long history with the juvenile courts. He is beginning to make some progress. I believe the court is aware that he had 2 misdemeanor charges pending. Those have been resolved by way of plea and sentence on Friday. So today's sentencing will have no effect on those. But I will say that the sentences that were meted out in those cases, as well as the plea agreement, is a recognition of the progress that Mr. Yates has made. And I do believe that he is an acceptable candidate for training status. Thank you.
Mr. Webb?
Thank you. I would also ask the court to follow the plea agreement and recommendation.
Are there any victims present to the issue of sentencing? No one in the courtroom, nobody on Zoom. Court has reviewed through the pre-sentence investigation report, does provide for sentencing guidelines of 2 to 17 months. This is an agreement for the home's youthful trainee. In order to punish you for what you have done, attempts to rehabilitation, protection of the community, the sentence of this court that be placed on probation for a period of 2 years as a home's youthful trainee, only on the felony charge. Is that correct with the agreement? It's only on the felony? Or is it on all 3?
Your Honor, I believe it's on, at least as it's stated, the CFJ 145, Briggs Kilber agreement had to hide it, so presumably for all counts.
No objection, Mr. Webb?
If I could have this second.
I will certainly cross-reference with the plea agreement.
Yeah, that's what I'm.
Your Honor, the petition that the defense filed indicates assault with a dangerous weapon, assault or assault and battery, and malicious destruction of property. So it was the defense understanding that we were proceeding on those 3 counts.
All right.
I would agree with that, Your Honor.
All right. So it'll apply to all 3 counts. In addition to the statutory terms of probation, you have the following special conditions. Must not use or possess alcoholic beverages or other intoxicants or enter any places that serve alcohol. Must comply with the requirements of alcohol testing as directed by the field agent. Must comply with the requirements of drug testing as directed by the field agent. Must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. You must complete outpatient or residential substance abuse treatment when referred by the field agent. You must complete a substance abuse assessment when referred by the field agent. You must complete a psychological evaluation when referred by the field agent. You must complete mental health, domestic violence, or other recommended treatment following assessment by a qualified community-based service provider. You must waive confidentiality and allow any treatment program that you are required to attend to disclose information to your field agent. You must not engage in any assaultive, abusive, or intimidating behavior. You must not have any verbal, written, electronic, or physical contact without permission of the field agent with anyone you know to have a felony record. You must not change your residence unless you first obtain written permission from the field agent. You must not use any object as a weapon. You must contact the supervising field agent no later than the first business day following your placement on probation or release from jail. You must comply with all written and verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person or property without the need of a warrant if the field agent has reasonable cause to believe you have items which violate your conditions of probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends, and holidays accepted. You must notify the field agent of service of any personal protection order upon you within 24 hours of that service, weekends, and holidays accepted. You must not have any verbal, written, electronic, or physical contact with Jonathan Cole, Robert Cole, Mia Holt, Clover Ann LaDePaulo, Alexis Mize, Chloe New, Kaylee Millspaw, Ryan Millspaw, Rachel Wing, and Melissa Slater, either directly or through another person, and you must not be within 500 feet of their residences, schools, or place of employment. You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours a week. You must pay $168 in state costs, crime victims assessment of $130, supervision fee of $30 a month. It can go up to $60 a month if the department puts you on electronic monitoring, $500 in court costs, a fine of $500. How much for attorney fees?
$170, $170.
$170 and court-appointed attorney fees. Court's going to order you to do 100 hours of community service. If you successfully complete the 100 hours, the court will reduce your fines and costs by $500. Probation officer of this court or any other supervising agent may, pursuant to MCL 771.4, apprehend, detain, and confine a probationer who is in violation of a probation condition or who is conducting himself inconsistent with the public good. Must not use, purchase, or otherwise possess recreational marijuana or be in the home or company of anyone who uses or possesses recreational marijuana. You must not possess, purchase, or attempt to purchase anything that contains ephedrine or pseudoephedrine without first obtaining permission from your field agent. You must set up an installment payment agreement with the Clare County Clerk's Office within 30 days of your placement on probation or release from jail. You do everything you're told? Mr. Yates? Don't get
Yes,
in any more trouble? You don't get in any more trouble, good things will happen. These won't remain as convictions on your record. But if you fail to follow all the rules, you're gonna come back in front of me for sentencing again. So make sure
Yes,
you
sir.
follow all the rules. All right? Did he get sentenced to jail on the other charges?
Time served, Your Honor.
Time, sir. So you will be getting released sometime today. The first place you go or contact is the probation department. Mr. Ween, any information for him about that when he gets released today?
Mr. Yats, you're going to be contacting Agent Medley.
Yes, sir.
Okay, do you have her number and contact information then?
No, sir.
Okay, what's a good telephone number for you upon your release?
My mom's number, 989-544-1706.
I'll provide that information to Agent Medley and she'll be getting in touch with your mother with contact information for you.
Thank you, sir.
All right, you're all set, Mr. Yates.
All right, thank you.
Okay.
Yes.
You're doing so good. You're doing good so far. You show promise, Mr. Webb.
Are you Mr. Fuller?
Yes, ma'am.
Okay, thank you. Then I have-
Calling the case of Big versus Jonathan James Fuller. Do that one first.
Morning, Your Honor. Morning, Your Honor. Mark Webb on behalf of the people.
First, Scott Moore for the defense. Mr. Fuller was recently transported to the Clare County Jail. I was unaware of that until this morning. I do know that the writ had been issued at the request of the prosecutor's office. If we could pass this matter for a moment and perhaps come to it later this morning, I'd appreciate it. Maybe a breakout room with Mr. Fuller at the court's convenience.
All right. We'll set this aside and we'll put Mr. Fuller in the waiting room for a few minutes.
Mr. Fuller, I'm gonna put you back in the waiting room for just a few minutes and we'll bring you back in about 5 or 10, okay?
Okay.
Just stay there.
Calling the case of Big versus Joshua Christopher Williams. Also identified for the record.
Good morning, Your Honor. Mark Webb on behalf of the people.
Please, the court, Scott Moore for the defense.
You are Joshua Christopher Williams.
Yes, Your Honor.
How old are you? Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
I don't understand. Your Honor, it's my understanding we're proceeding on counts 1 and 4.
Is that from? Pretrial summary, the 6th.
One that we signed August 12th.
There's a pretrial summary in the file, and the court has signed it and dated it. And you've gone over the information with Mr. Williams.
And Your Honor, waive reading of the information, waive preliminary examination.
Mr. Williams being charged with count 1, police officer fleeing in the 3rd degree. That's a felony that carries a maximum penalty of 5 years in prison and or a $5,000 fine. And the Secretary of State will suspend your driver's license with minimum discretionary with the court. And you're also being charged with count 4, motorcycles, mopeds operating without an endorsement, that's a misdemeanor, carries a maximum penalty of 90 days in jail and or a $500 fine. The minimum is discretionary with the court. You understand the charges and the possible penalties? There's one of three possible pleas you may make to these charges. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. You understand the one of three possible pleas you may make?
Yes, sir.
Answering to count one, police officer fleeing in the third degree, how do you plead?
Guilty. Guilty, Your Honor.
Answering to count four, motorcycles, mopeds operating without endorsement, how do you plead? You understand that no one may make any promises for this court as to what your sentence will be. Court further informs you that if your pleas are accepted, you will not have a trial of any kind and therefore give up the following rights. The right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so, and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes, sir.
You understand by pleading guilty, you give up each and every one of those rights.
Yes, sir.
Mr. Webb, what is the plea agreement?
Now, it's my understanding that in exchange for the defendant's guilty pleas to count one, fleeing, eluding third, and to count four, motorcycles, mopeds operating without an endorsement, the prosecution will dismiss counts, remaining counts at sentencing. It's also my understanding that if the defendant obtains an endorsement, we'll dismiss count four with proof of that at the time of sentence, and recommending no additional incarceration and restitution to be determined.
Mr. Moore, is that your full and complete understanding of the plea agreement?
I might not have heard this out. The plea to count one would be taken out of the Multi-Tool Training Act, and we have filed a petition requesting that.
That's correct.
IDA is not applicable to the misdemeanor traffic charge, so.
Okay.
It's not yet.
Okay.
But other than that, that is our complete full understanding of the plea agreement.
Mr. Williams, did you hear what was put on the record as the plea agreement?
Yes, sir.
Did you understand it?
Yes, Your Honor.
And are you in agreement with it?
Yes, sir.
Has anybody promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
No.
Has anybody threatened you or your family in order to induce you to plead guilty?
No, Your Honor.
I could have a moment with my client just briefly. We did have a plea agreement. We are promising that nothing beyond the plea agreement. You understand? Yeah. I don't find you sound a little bit concerned, so I just want to let you know. I don't think no other promises were made. You all right? So you're doing good. You're doing good. Thank you, Your Honor.
Has anybody promised you that if you pled guilty, this court would be lenient upon you in any way? You understand what the word lenient means?
Yeah.
Okay. All right. Is it your own personal choice to plead guilty?
Yes. Yes, Your Honor.
And are you doing so freely and voluntarily?
Yes.
Do you have any questions about what the court has told you?
Your Honor.
Have you understood everything the court has told you?
Yes, Your Honor.
In light of everything that the court has told you, do you still wish to plead guilty?
Yes, Your Honor.
Drawing your attention to on or about July 5th of 2021, were you driving a motor vehicle?
Yes, Your Honor.
And at the time, was it a motorcycle?
Yes, sir.
And did you have an endorsement for driving a motor
No,
vehicle?
Your Honor. I just bought a motorcycle and no.
Okay. And at some point, police come up behind you,
Yes, sir.
they put on their lights,
Yes.
they wanted you to pull over,
Yes, and I got scared.
you got scared,
I
and
was panicked and didn't know what to do, and I just bought this bike and.
Did you pull over immediately?
No,
In fact, they chased you for some distance.
sure.
And you knew they were performing their duties as police officers.
Yes.
Any questions, Mr. Webb, for a factual basis?
No, thank you, Your Honor.
And, was this in an area that the speed limit was 35 miles per hour or less?
Yes, sir.
Satisfied with the factual basis, Mr. Webb?
Yes, Your Honor.
Satisfied with the factual basis, Mr. Moore?
Yes, sir.
Does court comply with the court rules, Mr. Webb?
You have, Your Honor.
Does court comply with the court rules, Mr. Moore?
Yes, sir.
Court does not agree upon the possible plea or the possible sentence of either prosecutor or defendant or anyone acting in the interest of either. Court is convinced the plea is accurate and has been freely, voluntarily, understandingly, and knowingly made. The plea is accepted in order to enter upon the records of this court. Sentencing will be set for October 12th at 8:45 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Bond is continued. Mr. Ween, any questions or information from Mr. Williams?
Mr. Williams, if you could please come downstairs in the courthouse, I will hand you your packets for your PSI.
Yes, sir.
Thank you.
Okay, go ahead.
Here you go.
You gonna go into the jury room to, meet with Mr. Fuller?
Ma'am, can you identify for the court?
Yes, Your Honor. Thank you.
You wanna handle this, hope you can get this time?
Becky Woodbury?
Shouldn't take
Okay,
very
thank you,
long.
ma'am. Are you here for Corey Woodbury?
Yes.
Okay, I'm gonna go ahead and mute you until that case comes back, okay?
One more to check.
Could Kayleen Blair unmute her phone, please? Can the person with the phone identified as Kayleen Blair unmute their phone? Can you unmute your phone for me, Miss Blair?
Yes, sorry, I had to restart the app.
That's okay. Can you tell us what case you're here for today?
I am here for Corey Woodbury.
Okay, thank you very much. We're gonna put you back on mute. He'll be called in a few minutes, okay?
Okay, thank you.
Thank you.
Calling the case of People versus Crystal Lee Ovinia. Counsel identified.
Morning, Your Honor. Mark Webb on behalf of the people.
Yeah, please, of course, Scott Moore for the defense. My client is not in the court.
Set as a status conference. Any motions, Mr. Webb?
I'm not sure what her appearance history is, Your Honor. If this is her first time, I just asked her to show cause consent.
In all candidate, you mentioned Bar, no, this is not the
That's
first
not a
time.
first, Mr. Terrence.
I will say that we did have some sporadic contact with her. We sent her 2 letters in August, one covering today's notice to appear on August 3rd, another for district court hearing scheduled for September 15th. That was sent on August 19th. The last telephone number that we had, we text messaged Friday, advising her of today's date and time, inviting her to call me over the weekend, and asking her to confirm confirmation of these messages. No confirmation was received.
And court is going to cancel and revoke and forfeit her bond, issue a bench warrant for her arrest, amount of $50,000 cash. Court will hold off until Wednesday to issue that, so if you can get a hold of her and bring her to court, we'll go from there.
Thank you very much, Ron.
Mr. White, are you ready on Mr. Woodbury? Oh, I don't know. You're putting him in a breakout room with Scott. Scott's going in there to do a breakout room with Mr. Fuller. Okay. So, ready on Mr. Ware? Mr. White? Yeah. All right, where? And we keep calling case Pete versus Joseph Russell Ware. Counsel identify for the record, please.
Good morning, Your Honor. Mark Webb on behalf of the people.
Morning, Your Honor. I'm Gerald White representing Mr. Ware.
You are Joseph Russell Ware.
Yes, sir.
Previously, you appeared in court, pled to the charge of controlled substance, possession of methamphetamine, a felony that carries a maximum penalty of 10 years in prison. Minimum's discretionary with the court. Pre-sentence investigation report has been prepared. Sentencing guidelines have been determined to be 0 to 17 months. Mr. White, have you had an opportunity to review that pre-sentence investigation report with your client?
I have, Your Honor.
Anything of a factual nature that you wish to add to explain or controvert?
No, Your Honor.
Mr. Webb, on behalf of the people?
I've had a chance to review the report, Your Honor. I have no additions or corrections to make to it. The guidelines are correct in school.
Mr. Ware, is there anything you wish to say to the court before the court passes sentence?
No, sir.
Mr. White, on behalf of your client?
Well, Your Honor, I would indicate to the court, I would ask the court to follow the recommendations made by the prosecuting attorney's office as well as the probation department. We had a brief Killebrew in effect, offer in effect, there was no initial incarceration. And I would ask the court to follow that recommendation.
Mr. Webb, on behalf of the people?
And also ask you to follow the plea agreement and recommendations from the probation.
If I may speak, I saw something in the report here that I wanted the court to be aware of. That in the pre-sentence investigation on page 2, there's a recommendation of probation for a period of 2 years, and then seems to be a conflict with. Let's see here. Sorry, Your Honor. Let me see here. There was a recommendation for 18 months of probation. I'm looking for that area. It's on page, it also indicates page 2. It's on the pre-sentence investigation under the evaluation plan. So there's a conflict. That's all I want to point out to the court.
Okay. Duly noted. Court has reviewed through the pre-sentence investigation report that's provided for sentencing guidelines of 0 to 17 months. In order to punish you for what you've done, to attempt to rehabilitate you, to deter others from committing similar acts, protection of the community, to the sentence of this court, that you be placed on probation for a period of 2 years. Along with the statutory terms of probation, you must follow the following special conditions. You must not use or possess alcoholic beverages or other intoxicants or enter any places that serve alcohol. You must comply with the requirements of alcohol testing as directed by the field agent. You must comply with the requirements of drug testing as directed by the field agent. You must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. You must use prescription drugs only as prescribed for you by your licensed physician. You must complete outpatient or residential substance abuse treatment when referred by the field agent. You must complete a substance abuse assessment when referred by the field agent. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not have any verbal, written, electronic, or physical contact without permission of the field agent with anyone you know to have a felony record. You must not change your residence unless you first obtained written permission from the field agent. You must not use any object as a weapon. You must contact the supervising field agent no later than the first business day following your placement on probation. You must comply with all written and verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your personal property without the need of a warrant if the field agent has reasonable cause to believe you have items which violate your conditions of probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends, and holidays accepted. You must notify the field agent of service of any personal protection order upon you within 24 hours of that service, weekends, and holidays accepted. You must pay a $68 state cost, pay a crime victims assessment of $130, pay a supervision fee of $30 a month. It could go up to $60 a month if the Department of Corrections decides to put you on electronic monitoring. Court costs of $500, a fine of $500. How much are you charging for attorney fees?
$680, Your Honor.
$680 in attorney fees. Probation officer of this court or any other supervising agent may, pursuant to MCL 771.4, apprehend, detain, confine a probationer who is in violation of a probation condition or who is conducting himself inconsistent with the public good. Must not use, purchase, or otherwise possess recreational marijuana and or be in the home of or company of anyone who uses or possesses recreational marijuana. You must not possess, purchase, or attempt to purchase anything that contains ephedrine or pseudoephedrine without first obtaining permission from the field agent. You must set up an installment payment agreement with the Clare County Clerk's Office within 30 days. You must pay. At this point, there is no restitution, so that'll be left open. And the court's going to order you to do 40 hours of community service. You are entitled to appellate review of your conviction and sentence. If you're unable to hire your own attorney, the court will appoint an attorney for you and furnish the attorney with the necessary records and transcripts to perfect an appeal. The request for the appointment of appellate attorney must be made in writing within 42 days, sent directly to the court. Please sign the notice of appellate rights form. Bond is canceled. You see a probation officer before you leave here today. Mr. Wayne, do you want him to report down there or to call somebody?
He can report downstairs, Your Honor.
All right.
Your Honor, I didn't get a chance for allocution, but that's
Oh,
okay.
I thought you did.
The one thing I did want to add is that part of the agreement was for him to testify truthfully against Eric Heron if he's so called upon to do.
We'll still have to comply with that if necessary, otherwise you could come back for resentencing.
Thank you.
You're all set, Mr. Ware. In case of people, this is Jeffrey Stevens, Cicero Horton.
Judge, if I can have a minute,
You can have a minute.
thank you.
Your parents, Mr. Mr. White.
Yes, Your Honor, Gerald White, representing Mr. Horton.
Sorry, good morning, Your Honor. Mark Webb on behalf of the people.
You are Jeffrey Stevens' Cicero Horton?
Yes, sir.
Still need additional time to, Mr. Webb?
Yeah, about another minute or so.
Uh,
Thank you, I'm ready.
Alright. Previously, Mr. Horton, you appeared in court and pled to the charge of police officer fleeing in the third degree. A felony carries a maximum penalty of 5 years in prison. You also pled to the charge of police officer assaulting, resisting, or obstructing. A felony carries a maximum penalty of 2 years in prison. The minimums are discretionary with the court. Pre-sentence investigation report has been prepared. Sentencing guidelines on the most serious charge have been determined to be 0 to 11 months. Mr. White, have you had an opportunity to review that pre-sentence investigation report with your client?
I have, Your Honor.
Anything of a factual nature that you wish to add to, explain, or controvert in that report?
No, Your Honor, it appears to be accurate.
Any challenges to the scoring of the guidelines?
No.
Mr. Webb, on behalf of the people?
Thank you, Your Honor. I've had a chance to review the report. I have no additions or corrections to make to it, and the guidelines are correct as well.
Mr. Horton, is there anything you wish to say to the court before the court passes sentence?
No, sir.
Mr. White, that's your client?
No, Your Honor, I would ask the court to follow the recommendations that have been made by not only the prosecutor's office, but also the probation department. And as I indicated here, the report does appear to be accurate as far as the incident is concerned. So I have nothing further to add.
Mr. Webb, on behalf of the people?
Thank you, Your Honor. I'd also ask the court to follow the plea agreement and the recommendations by the probation department.
Victims present that wish to speak to the issue of sentencing. Let the record reflect there are no victims present in the courtroom. Apparently none on Zoom. Court has reviewed through the pre-sentence investigation report does provide for sentencing guidelines of 0 to 11 months. In order to punish you for what you have done, to attempts to rehabilitate you, deter others from committing similar acts of protection of the community, be the sentence of this court that you be placed on probation for a period of 1 year. Along with the statutory terms of probation, you have the following special conditions. You must comply with the requirements of alcohol testing as directed by the field agent. You must comply with the requirements of drug testing as directed by the field agent. You must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. You must complete outpatient or residential substance abuse treatment when referred by the field agent. You must complete a substance abuse assessment when referred by the field agent. You must perform 100 hours of community service as directed by the field agent. If you successfully complete those 100 hours, the court will reduce your fines and costs by $600. You must complete a psychological evaluation when referred by the field agent. You must complete mental health or domestic violence or other recommended treatment following an assessment by a qualified community-based service provider. You must waive confidentiality and allow any treatment program that you are required to attend to disclose information to your field agent. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not have any verbal, written, electronic, or physical contact without permission of the field agent with anyone you know to have a felony record. You must not change your residence unless you first obtained written permission from the field agent. You must not use any object as a weapon. You must contact the supervising field agent no later than the first business day following your placement on probation or release from jail. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person or property without the need of a warrant if a field agent has reasonable cause to believe you have items which violate your conditions of probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours a week. You will serve 180 days and count credit for 108 days served. You must comply with DNA testing and pay a $60 fee. The court's going to suspend the remainder of that 180 days. You must pay $136 in state costs, comply with DNA testing, pay a crime victims assessment of $130, pay a $30 supervision fee. That could go up to $60 if the Department of Corrections decides to put you on electronic monitoring. Court costs of $500, a fine of $500. How much for attorney fees?
Excuse me, Your Honor, 420.
$420 in court-appointed attorney fees. Probation officer of this court or any other supervising agent may, pursuant to MCL 771.4, apprehend, detain, and confine a probationer who is in violation of probation condition or is conducting himself inconsistent with the public good. You must not use, purchase, or possess recreational marijuana and or be in the home or company of anyone who uses or possesses recreational marijuana. You must not possess, purchase, or attempt to purchase anything that contains ephedrine or pseudoephedrine without first obtaining permission from the field agent. You must set up an installment payment agreement with the Clark County Clerk's Office within 30 days for the payment of those fines and costs. You are entitled to appellate review of your convictions and sentences. If you're unable to hire your own attorney, the court will appoint an attorney for you and furnish the attorney with the necessary records and transcripts to perfect an appeal. The request for the appointment of appellate attorney must be made in writing within 42 days sent directly to the court. Please sign the notice of appellate rights form. Bond is canceled. Mr. Wayne, would you like him to report down to your office after this or call somebody?
You can come downstairs, Your Honor.
All right. Mr. Horton, you need to go downstairs to the Department of Corrections and meet with the corrections officer. Good luck to you.
Thank you, Your Honor. Have a good afternoon.
Thank you, sir. I believe Mr. Wright will come in. He logged off.
Mr. Fuller still in the room with him though?
I think, yeah. But they have to bring him back.
All right, we'll take a short recess until we're ready to go. We have to wait for Mr. Woodbury until Mr. Moore is done with his time.
All right.
Mr. Fuller, it'll just be a few minutes, okay?
All rise. Fifth District Court is back in session. Honorable Roy G. Meek presiding.
You may be seated. Calling the case of people versus Jonathan James Fuller. Counsel identified for the record, please.
Good morning, Your Honor. Mark Webb on behalf of the people.
And please, the court, Scott Moore for the defense.
You are Jonathan James Fuller?
Yeah, but there's nobody on the screen.
This was set as a status conference. You talked with your. Did you say something, Mr. Fuller?
There's nobody there. Like the whole courtroom's like it was.
Mr. Fuller, can you hear me?
Yes.
All right, I'm standing in the well of the courtroom. The judge is off to my left on the screen. And the prosecutor.
Yeah, no, all they do is bailiff.
So set as a status conference, you've been able to talk to your client this morning, Mr. Moore?
I have, Your Honor. It's a matter of record that my client has been charged with new offenses in Ogama County. He is pending sentencing in Oceana County sometime in October. These events will have a bearing on the ultimate resolution of the case, as well as some motions that my client's asked me to explore. In light of all this, I have two requests. First, that this matter be adjourned for another status conference in approximately 30 to 45 days, and that if a bond is posted in this case, that be canceled. I understand that my client is on parole, but I don't want there to be any question about his bond status at the end of this case.
All right. So the bond will be canceled. We'll set this for a status conference in approximately 30 days.
Thank
you. Care of all your cases this morning.
Yes, sure. Thank you very much.
All right. You're all set, Mr. Fuller.
Thank you. Yeah.
Oh, shoot, that's right.
Mr. Woodbury, you're bringing next, correct?
He's next in the queue.
Mr. Fuller, you can leave the room now.
Thank you.
Good morning. Can the person with the phone number ending in 903 identify for the court?
On the cases of the people versus Corey Michael Woodbury, counsel identify for the record, please.
Good morning, Your Honor. Mark Webb on behalf of the people.
Good morning, Your Honor. Gerald White representing Mr. Woodbury.
You are Corey Michael Woodbury?
Yes, sir.
Previously, you appeared in court and pled to some charges. Case number 6452, you pled to controlled substance, possession of methamphetamine, a felony. It carries a maximum penalty of 10 years in prison. Minimum is discretionary at the court. You also pled to the charge of operating while license suspended, revoked, denied, or allowing the suspended person to operate a motor vehicle. A misdemeanor carries a maximum penalty of 93 days in jail. You also pled in file number 20-6453-FH to weapons, firearms, possession by a felon, a felony that carries a maximum penalty of 5 years in prison, and controlled substance possession of a narcotic less than 25 grams, a felony carries a maximum penalty of 4 years in prison. Minimums are discretionary with the court in all four charges. A pre-sentence investigation report has been prepared. Sentencing guidelines on the controlled substance possession of methamphetamine are 10 to 23 months. And sentencing guidelines on the weapons, firearms possession by a felon are 7 to 23 months. Mr. White, have you had an opportunity to review that pre-sentence investigation report with your client?
I had Your Honor this morning.
Is there anything of a factual nature that you wish to add to explain or controvert?
No, it appears to be accurate.
Any challenges to the scoring of the guidelines?
No challenges, Your Honor. Thank you.
Mr. Webb, on behalf of the people?
Thank you, Your Honor. I've read the reports, I have no additions or corrections to make to them, and the guidelines are correctly scored.
Mr. Woodbury, is there anything you wish to say to the court before the court passes sentence?
Yes, sir. I just want to say I'm trying to put all this behind me. I got a good support system. I accept my doings of what happened, and I'm just trying to move forward with my life. I was 2 weeks clean before I came in, and I want to continue my sobriety. I feel progression, and I feel like I'm doing better with myself. So, with the court's discretion, I just wish everything goes as planned.
All right. Mr. White, on behalf of your client?
Well, Your Honor, I would indicate for the court that representing Mr. Woodbury through these times, these matters pending before this court are now to be concluded in this court, I would simply ask the court to follow the recommendation made by the prosecutor's office as well as the Michigan Department of Corrections pursuant to the Briggs-Killebrew Agreement.
Mr. Webb, on behalf of the people?
Thank you. I would also ask you to follow the plea agreement recommendations of the probation department.
Court has reviewed through the pre-sentence investigation report. Does provide for sentencing guidelines of 10 to 23 months on the possession of methamphetamine and 7 to 23 months on the possession of a weapon by a felon or a firearm. In order to punish you for what you have done, to attempts to rehabilitate you, deter others from committing similar acts in protection of the community, be the sentence of this court that you be placed on probation for the felonies in both cases for a period of 3 years. Not putting you on probation on the misdemeanor charge. Along with the statutory terms of probation of the following special conditions. Must not use or possess alcoholic beverages or other intoxicants or enter any places that serve alcohol. Must comply with the requirements of alcohol testing as directed by the field agent. You must comply with the requirements of drug testing as directed by the field agent. You must not use or possess any controlled substance or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. You must use prescription drugs only as prescribed for you by your licensed physician. You must complete outpatient or residential substance abuse treatment when referred by the field agent. You must take medications only as prescribed by your licensed physician. You must participate in adult education or a GED program as directed by the field agent. You must waive confidentiality and allow any treatment program that you are required to attend to disclose information to your field agent. You must not engage in any assault of abusive, threatening, or intimidating behavior. You must not use any object as a weapon. You must contact the supervising field agent no later than the first business day following your release from jail. You must comply with all written and verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person or property without the need of a warrant if the field agent has reasonable cause to believe you have items which violate your conditions of probation. You must not drive a motor vehicle unless you first obtain written permission from the field agent. You must reside in an approved residence, not change your residence unless you first obtain written permission from the field agent. You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours a week. You will serve 12 months in the county jail on the 3 felony charges. Misdemeanor charge, the sentence is going to be 93 days. You get 75 days credit. I believe that applies to the driving while license suspended charge and the meth amphetamine charge, I think you get 76 days on the weapons and controlled substance less than 25 gram charge. Number 20-6452-FH, you must pay $118 in state costs. Crime victims assessment of $130. You'll pay a supervision fee of $30 a month unless you're paying it in another county. And that could go up to $60 a month if the Department of Corrections decides to put you on electronic monitoring. Court costs of $500, a fine of $500. How much are you charging for attorney fees in that case?
$1,230, Your Honor.
$1,230?
Yes.
All right. Does that cover both or just the one?
Both.
Both cases, okay, and we'll just put it in that file. Probation officer of this court or any other supervising agent may pursuant to MCL 771.4 apprehend, detain, confine a probationer who is in violation of probation condition or who is conducting himself inconsistent with the public good. You must not use, purchase, or otherwise possess recreational marijuana or be in the home or company of anyone who uses or possesses recreational marijuana. You must not possess, purchase, or attempt to purchase anything that contains ephedrine or pseudoephedrine without first obtaining permission from the field agent. You must set up an installment payment agreement with Clark County Clerk's Office within 30 days of your release from jail. As to file number 20-6453-FH, you must pay $136 in state costs. Crime victims assessment of $130. Be no fines or costs or attorney fees in that file. You are entitled to appellate review of your convictions and sentences. If you're unable to hire your own attorney, the court will appoint an attorney for you and furnish the attorney with the necessary records and transcripts to perfect an appeal. The request for the appointment of appellate attorney must be made in writing within 42 days sent directly to the court. Please sign the notice of appellate rights form when it's presented to you. Bond is canceled, handed to the custody of the Sheriff's Department for carrying out the sentence. Good luck to you, Mr. Woodbury.
Thank you, sir. Is there any way I can speak to my lawyer?
What'd you say?
Is there any way I can speak to my lawyer?
Can you set up a Zoom to speak with them later?
Or I can do that later on.
Yeah.
Is that all right, Corey?
Yes, sir. Just let my mom and them know. I'm kind of confused on what's going on. Like, is that for both my charges together or what?
Yes. We had some people Zoom in and listen to this. So one of them appears to be your mother.
All right. Thank you.
All right.
I can't see you guys in the court. Oh, there it goes.
Oh.
No, I can't.
All right. You're all set.
All right. Thank you.
All these charges run concurrent too, so.
All right. Thank you very much. Have a good day.
Thank you.
Thank you.
Mr. Diedrich, can you hear the court?
Yes.
Do you have your client with you?
No, is it Miss Bowling?
Yes.
I believe she's still in the Clark County Jail.
She should be up next
All
after.
right, she'll be up next.
Okay, I'm gonna identify people.
Okay.
Could the person with the phone number ending in 903 unmute and identify for the court?
Hello,
Hello, can you identify for the court?
Richard Reed, REID.
I don't know how to get out of here.
Thank you. put you back into the waiting room until your case is called. Don't hang up, okay?
Okay.
Thank you. Can the person with the phone number with the area code 231 identify for the court? Can you identify for the court if your phone number ends in 615?
Michael Pink?
Michael Pink?
Yes.
Thank you, sir. I'm gonna put you back in the waiting room until your case is called, okay?
Thank you very much.
Thank you. We lost you. Just FYI. Can the person with the phone number ending in 142 identify for the court, please?
Ernie Doran?
I'm sorry, can you say your first name again?
D-E-R-N-R.
Thank you, Mr. Dorn. Mr. Dorn, we're gonna put you back in the waiting room until your case is called, okay?
Thank you.
Thank you. Did you let the jail know they're gone?
They should be bringing.
No, I mean, their Zoom is gone.
They have to reset it.
They have to reset it.
They lost the connection.
Oh, okay.
Yeah.
Of course, we're going to corrections. The Zoom is gone. They're saying that you need to reset it.
Can the person with the Galaxy A01 phone unmute their phone and identify for the court? Nope, I got time. Yeah. Would the person with the Galaxy phone identify for the court, please?
Michelle Hines.
Michelle Hines, are you here for David Hines?
Yes, ma'am.
Okay, that case has not been called yet, but we'll bring you back in when it has been, okay?
Thank you, ma'am.
You're welcome.
We'll take a short recess.
All rise. Be seated.
Is Karen?
Karen's here.
Karen's here. So the jail still isn't up?
What did you see?
But I
Are you crying?
It keeps telling me
I'm
that
trying to
my
get rid of the
connection
bags.
is
They just-
unstable.
I got them too
They
today.
just say clear.
I got them all.
We're twins.
You need to go ahead and pull it back up and
Oh.
reboot.
That special cream that I put in there doesn't work.
Oh,
I know.
man.
Hey, Cal, it keeps saying that our connection is unstable. I'm pretty sure it's.
I wouldn't stay.
Think it's.
I know you are.
So
Not my
it's-
connections.
Do you want to just do it by,
I mean, it keeps.
do you want to do it just by
Like,
phone
when
then?
he couldn't see us, it's because it kept flashing, connection unstable. He could hear us, but he couldn't see us.
Okay, and that's from our side?
Yeah, I don't know. If we're on the same. Ms. Mackey, if you can enable your microphone so we can see who you're here for, please.
Okay.
Used to judge, they came and got.
Oh, they came and got some?
Ms. Mackey, I still don't have audio for you. I'll need you to enable your microphone so we can hear you. Do you have a sign over there still?
Yeah.
Do you have a sign?
Audio off. Let me see.
Turn it.
Can you see it?
No, see the camera on the left?
There. Okay. Where's your
You missed a bell.
stick that? See, right now, because I lost weight, I don't wear my regular belt. I just wear this.
All right.
Yeah.
I just wanted to trick you.
Oh.
You could have slapped my hand if I would have grabbed you. All right, just.
If I could get my hand behind there. I'm going in for carpal tunnel surgery. I'm gonna feel- No, honey, I don't know what that to do with it.
Oh.
One of the guys on the monitor division wears his gloves, no fingers, and he come up. And that supports him. Turns it.
Does it?
Because he doesn't want to get this surgery.
Go get.
All right, Fifth District Court is back in session. Roy G. Mink presiding.
May be seated. In the case of People versus Amanda Bowling, counsel identify for the record, please.
Good morning, Your Honor. Mark Webb on behalf of the people.
Thank you, Your Honor. Todd Diedrich appearing on behalf of Ms. Bowling.
You are Amanda Elizabeth Bowling.
Yes, sir.
This was set for an arraignment. How do you wish to proceed today, Mr. Diedrich?
Your Honor, we're going to ask the court to allow us to waive the arraignment today, just to advise the court. This case is on path for possibly going into recovery court. I just wasn't sure how fast that process would happen, but we're just not quite there yet. So I didn't do anything so I could just see where we were, and we're just not there yet.
All right, not guilty pleas will be entered on behalf of the defendant. This will go on the trial docket with the pretrial being scheduled next.
Thank you, Your Honor.
All right, you're all set.
Thank you, Your Honor.
Good morning, Ms. Thompson. Can you unmute your phone, please? And Ms. Bowling, you're all set.
Okay, thank you.
Thank you.
On the case of the people versus Christopher Scott Askew. Counsel identify for the record, please.
Morning, Your Honor. Mark Webb on behalf of the people.
Thank you, Your Honor. Karen Tomczyk on behalf of Mr. Askew.
You are Christopher Scott Askew?
Yes, Your Honor.
All right, this is set as a pretrial today. Pretrial summary has been forwarded to the court. Have you received that, Ms. Tomczyk?
I have, Your Honor.
All right. Court is signing it.
Your Honor, we could enter a plea today if the court would set sentencing out. I would say 2 to 2.5 months so Mr. Askew can get some dental work, or we could set this for another plea date.
All right, so like sentencing in November or something? November, December?
Would that be enough time, Mr. Askew?
Yes, that would be enough.
How old are you, Mr. Askew?
46.
Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And Mr. Askew, you've seen or gone over the information with your attorney, is that correct?
Yes, Your Honor.
Ms. Tomczyk, is he waiving reading of the information for today's purposes and preliminary examination?
Yes, Your Honor.
All right. Mr. Askew, you're being charged with count 1, operating while intoxicated. Third offense, that is a felony. It carries penalties of $500 to $5,000, either 1 to 5 years in prison or probation with 30 days to 1 year in jail. You'll be ordered to do at least 60 days of community service. It could be up to 180 days. You'd be ordered into rehabilitative program, pay costs of prosecution, reimburse the government for any emergency response, mandatory vehicle immobilization of not less than 1 year or more than 3 years. Otherwise, the minimum is somewhat discretionary with the court as to that charge. You're also being charged with count 3, alcohol, open container and vehicle. That's a misdemeanor, carries a maximum penalty of 90 days in jail and or $100 fine. You'll be ordered to do community service and substance abuse screening. You understand the charges and the possible penalties?
Yes, I do, Your Honor.
There's one of 3 possible pleas you may make to these charges. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. You understand the one of 3 possible pleas you may make?
Yes, Your Honor.
Answering the count 1, operating while intoxicated, third offense notice, how do you plead?
Guilty.
Answering the count 3, alcohol, open container and vehicle, how do you plead?
Guilty.
You understand that no one may make any promises for this court as to what your sentence will be.
Yes, Your Honor.
Court further informs you that if your pleas are accepted, you will not have a trial of any kind and therefore give up the following rights: the right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent, not have that silence used against you during trial, and the right to testify at trial if you wish to do so, and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes, Your Honor.
You understand that by pleading guilty, you give up each and every one of those rights.
Yes, Your Honor.
Mr. Webb, what is the plea agreement?
Your Honor, it's my understanding the defendant will plead guilty to OWI third and to the open intox count. The habitual second will be dismissed at sentencing along with any remaining counts. There's no sentence recommendation or agreement. There's restitution, which is $150 to law enforcement, and actual cost of prosecution. And I believe that is the extent of the agreement.
Ms. Tomczyk, is that your full and complete understanding of the plea agreement?
It is, Your Honor.
Mr. Askew, did you hear it was put on the record as the plea agreement?
Yes, Your Honor.
Did you understand it?
Yes.
And are you in agreement with it?
Yes, I am, Your Honor.
Has anybody promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
No.
Has anybody threatened you or your family in order to induce you to plead guilty?
No.
Has anybody promised you to plead guilty to this court to be lenient upon you in any way?
No.
Is it your own personal choice to plead guilty?
Yes.
And are you doing so freely and voluntarily?
Yes.
Do you have any questions about what the court has told you?
No.
Have you understood everything that the court has told you?
Yes, Your Honor.
In light of everything that the court has told you, do you still wish to plead guilty?
Yes, Your Honor.
Drawing your attention to on or about June 16th of 2021, where you operated a motor vehicle on Clare Avenue in Hayes Township, Clare County, Michigan.
Yes, Your Honor.
And prior to driving that motor vehicle, had you been drinking some alcohol?
Yes, Your Honor.
Do you remember what kind of alcohol?
It was vodka.
Vodka. Do you know how much you drank?
I relapsed and drank a whole pint.
A whole pint? Okay.
Before I left the party.
And then, did that make you intoxicated?
Yes.
All right. Did you end up taking a breathalyzer or a blood test?
I did.
Do you recall what the results were?
I believe it was 1.7.
Your Honor, it was 0.13.
0.13? May the court take judicial notice of that?
Yes, Your Honor.
All right. And that is above the statutory level that they're allowed to do. And at the time, did you have a container of alcohol in the car?
Yes, Your Honor.
And it was opened or non-capped or?
Yes, Your Honor.
And was that the vodka or something
It
else?
was the beer I got with the vodka.
Oh, that chased it out. All right, so you had open beer.
Yeah, it was full.
All right. And is it true that you were previously convicted of operating while intoxicated on October 30th, 1996 in the 86th District Court for Antrim County, State of Michigan?
I looked it up and I pled guilty. I didn't remember that,
Long
but
time
yes,
ago.
yes, I did. I was pled guilty to it.
Right. And were you also convicted operating while impaired on March 11th of 2020 in the 8th District Court for Clare County, State of Michigan?
Yes, Your Honor.
Prosecutor satisfied with the factual basis?
Yes, Your Honor.
Satisfied with the factual basis, Ms. Tomczyk?
Yes, Your Honor.
Has court complied with the court rules, Mr. Webb?
You have, Your Honor.
Has court complied with the court rules, Ms. Tomczyk?
It has, Your Honor.
Court has not agreed upon possibly or the possible sentence to either the prosecutor, defendant, or anyone acting in the interest of either. Court is convinced the plea is accurate and has been freely, voluntarily, understandably, and knowingly made. Plea is accepted and ordered entered upon the records of this court. Sentencing will be set for December 13th at 10 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Bond is continued. Case is adjourned to the date time says for sentencing. Mr. Wayne, do you want him to report down to get a pre-sentence packet?
Yes, Your Honor.
All right. So, Mr. Askew, we're going to ask you to go downstairs to the Department of Corrections and pick up a pre-sentence investigation packet.
All right. Thank you, Your Honor.
And Your Honor, if I could get notice of the pre-sentence investigation interview?
All right. keep in contact with them if they don't get, with your client or Department of Corrections if they don't get in contact with you for the date, okay?
I will do, Your Honor. Mr. Askew, call my office and set an appointment so we can discuss that pre-sentence investigation report.
Will do. Have a good day.
Okay. Calling the case of the People versus Richard Joseph Reed.
Yes, I'm here.
Counsel identified for the record.
Richard Reed, REID.
All right, I asked for attorneys to put their appearance on the record, Mr. Reed.
Thank you.
Go ahead.
Good morning, Your Honor. Mark Webb on behalf of the people.
Good morning, Your Honor. Karen Tomczyk appearing on behalf of Mr. Reed.
All right, and we already have Mr. Reed's appearance on the record. And they said as a status conference, we do have a final pretrial set for the September 28th. Anything you wish to discuss today? Everything going okay? You got discovery and everything?
Your Honor, I do have discovery. This was set as a status conference because the last hearing actually fell when there was no internet at the courthouse and the prosecutor's office. So I would just leave that on for the final pretrial. And I will touch base with my client and let the prosecutor know if he chooses to accept the offer.
Any comment, Mr. Webb?
No, Your Honor.
All right. All right, I guess we'll see you again on September 28th. Mr. Reed, keep in contact with your attorney. You're all set for today.
Okay, thank you.
The jail is gone again. I
The
just
jail
brought
is
them in
gone?
and they disappeared.
Court security to corrections, the Zoom is down again.
Do you have anybody in the waiting room?
David Hines.
Do that is the last. Karen, we have Mr. Reynolds.
See Mr. Rowe there. I was wondering if any of his clients are on in the waiting room.
I have Samantha Carter. I can bring her.
Okay, let's do that. Calling the case of the People versus Samantha Ann Cardos. Counsel identify for the record, please.
Good morning, Your Honor. Mark Webb on behalf of the people.
Your Honor, Austin R. Rowe appearing on behalf of Ms. Cardos.
You are Samantha Ann Cardos?
Yes.
All right. Today was set as a pretrial. A pretrial summary has been forwarded to the court. Did you receive that, Mr. Rowe?
I have received that, Your Honor.
Court is signing it for the record. Anything further you want to do today on this case, Mr. Rowe?
Your Honor, on this case, I believe this was the same offer that was made down in district court at the probable cause conference. Ms. Cardos, do you remember talking about that with me?
Yeah.
Is that the offer you'd like to accept, or do you want to go to trial?
The offer is for an agreement of no initial incarceration plus a term of probation. You understand that, Ms. Cardos?
Yeah.
All right.
If you want to think about it more, Ms. Cardos, we can just go on and proceed to trial, and in the meantime, you and I can talk about it. Is that what you'd rather do?
Yeah.
Okay. Your Honor, at this time, we'll proceed on to trial.
All right. So this will continue on the trial docket with the final pretrial being scheduled next. Do you want a status conference before that final pretrial?
Yes, Your Honor.
All right, we'll set a status conference for the first motion day in October, and then a pretrial after that. for our final pretrial after that.
Thank you.
All right. You're all set, Ms. Cardos. You can sign off.
Thank you.
I still do not have the jail.
All right. So what's Mr. Doran then? Calling the case of People versus Bernie Chance Doran.
Yes, can you hear me?
Can hear you, Mr. Doran.
Judge,
Yes.
All right. Your appearance, Mr. Rowe?
Your Honor, Austin R. Rowe, appearing on behalf of Mr. Doran. Mr. Doran and I briefly talked about his.
So you need a breakout room?
Yes, Your Honor, I do.
All right. Court is in recess.
All right.
All right, Mr. Rowe, it'll just be a second, and Mr. Doran, just accept when it says to go into a breakout room.
Okay.
Is the Zoom up and running yet?
Here you go, gentlemen.
Court's back in session. Honorable Roy G. Mink presiding.
You may be seated. Calling the case of People versus David Ryan Hines. Counsel identify for the record, please.
Thank you, Your Honor. Terry Tomczyk appearing on behalf of Mr. Hines.
Yes, this is David Ryan Hines.
All right. Mr. Webb, your appearance?
Sorry, Your Honor. Good morning, Your Honor. Mark Webb on behalf of the people.
All right. Previously, Mr. Hines pled to probation violations. He's currently on probation for domestic violence, third offense, a felony that carries a maximum penalty of 5 years in prison. Minimum is discretionary for court. Original sentencing guidelines were 0 to 23 months. An updated case report has been provided to the court. Have you received that, Ms. Tomczyk?
Yes, Your Honor.
Have you reviewed it with your client?
Yes, Your Honor.
Anything of a factual nature that you wish to add to explain or controvert?
No, Your Honor.
Mr. Webb, on behalf of the people.
Your Honor, looking to see if we have that updated report. I don't see it.
You want to look at the court's copy?
Yes, thank you.
All right, there it is. Anything of a factual nature that you wish to add to explain or controvert in that report?
No, thank you, Your Honor.
All right. Mr. Hines, is there anything you wish to say to the court before the court passes sentence?
No, Your Honor.
All right. Ms. Tomczyk, on behalf of your client?
Yes, Your Honor. We would ask that the court consider sentencing Mr. Hines to time served and an unsuccessful discharge of probation. The difficulty in this case, Your Honor, is that Mr. Hines is homeless and that He's been staying in homeless shelters, most recently the one up in Traverse City. He indicates to me that he does not plan on going back there. But probation cannot transfer to the counties that he's staying in because he's in homeless shelters and those counties won't take him at that point. And so it's been difficult for Mr. Hines to try and get on his feet and still make all of his reporting requirements, Your Honor. So again, Mr. Hines has 62 days credit. We'd ask that you sentence him to 62 days, unsuccessfully discharge him from probation with all costs and fines still remaining.
Mr. Webb?
Your Honor, this defendant has 25 prior misdemeanors and 2 prior felony convictions. And this is a domestic violence third. I'd ask for a year in the county jail.
Mr. Hines' case is up in Grand Traverse County, all settled? Is he done, or is he still got to go to court there?
He still has to go to court there, Your Honor, but they are misdemeanor charges for things like disorderly.
It's a difficult case. In order to punish you for what you have done, attempts to rehabilitate you, deter others committing similar acts, protection of the community, it's going to be a sentence of this court that you be sentenced to 9 months in the county jail with credit for 62 days served. No additional fines and costs. Court is going to remove the fine in this case, remove the court costs in this case. The remaining fees are still be there. So we'll reduce your costs by $1,000, Mr. Hines. And if you make some payments, if you can make some payments in the future, the court would look favorably at reducing some of the other costs later on. All right.
Yes, Your Honor.
All right. You are entitled to appellate review of your conviction and sentence. If you're unable to hire your own attorney, the court will appoint an attorney for you and furnish the attorney with the necessary records and transcripts to perfect an appeal. The request for the appointment of appellate attorney must be made in writing within 42 days, sent directly to the court. Bond is canceled, probation is canceled. Remanded to custody of Sheriff's Department for carrying out the sentence. Good luck to you, Mr. Hines.
Yes, thank you, ladies and gentlemen, thank you. Good luck.
Okay.
I believe that's all my matters. Thank you, Your Honor.
All right, thank you. Rowe is back. We have Mr. Doran.
Yes, we're ready with Mr. Doran.
All right.
Mr. Doran, can you hear the court?
Yes, ma'am.
Okay, thank you.
Recalling the case of People versus Bernie Chance Doran, counsel identify for the record again.
Good morning, Your Honor. Mark Webb on behalf of the people.
Your Honor, Austin R. Rowe on behalf of Mr. Doran.
And you are Bernie Chance Doran, is that correct? Previously, you appeared in court and pled to the charge of controlled substance possession of methamphetamine, a felony that carries a maximum penalty of 10 years in prison. The minimum is discretionary with the court. A pre-sentence investigation report has been prepared. Sentencing guidelines have been determined to be 0 to 9 months. Mr. Rowe, have you had an opportunity to review that pre-sentence investigation report with your client?
I have, Your Honor.
Anything of a factual nature that you wish to add to, explain, or controvert?
Well, Your Honor, it says that Mr. Doran has 13 days jail credit. I was talking with Mr. Doran. He says it should be 1 day.
Okay. All right, we'll have the Department of Corrections check into that and amend it if necessary, so. Anything else?
No, Your Honor.
All right. Any objection to the scoring of the guidelines?
No, Your Honor.
And is your client waiving the right to be present in the courtroom for sentencing today?
He is, Your Honor.
All right. Mr. Webb, on behalf of the people, anything regarding the report?
No, thank you. I've reviewed the required additions, corrections to make to it, and the guidelines are correctly scored.
Mr. Doran, is there anything you wish to say to the court before the court passes sentence?
No, Your Honor.
Mr. Rowe, on behalf of your client?
Your Honor, on behalf of my client, I'm looking at his criminal record as reported in the PSI. Except for a use of tobacco as a minor back in 2006. This would be his first substance abuse type case. Furthermore, to argue with what the writer of the report said, that he has multiple convictions, that's true, but kind of qualified. I think it puts Mr. Doran in a false light. According to the PSI, he only has 4 convictions as an adult, including this case. One is receiving and stolen conversion, a misdemeanor conversion case. Another one is failure to stop after an accident. And finally, the third one is forgery, Your Honor. So Mr. Doran is asking the court for 7411 status. He would ask also the court that usually in 7411 status, there's no initial incarceration. The corrections officer is recommending incarceration. We ask the court to do what it usually does, especially since Mr. Doran, except for the minor in possession of tobacco as a juvenile, Mr. Doran has not had a substance abuse conviction before. We ask the court to allow Mr. Doran to have no initial incarceration in this case, Your Honor.
All right. Mr. Webb, on behalf of the people.
Your Honor, I would ask you to, I'll take no position on the 7411. I'll leave that to your discretion. And I'll also leave any jail time up to the court.
All right. The court has reviewed through the pre-sentence investigation report does provide the sentencing guidelines of 0 to 9 months. Mr. Doran is eligible for 7411 status, and the court will point out that it's been about 9 years since his last conviction. In order to punish you for what you have done, to attempts to rehabilitate you, deter others from committing similar acts in protection of the community, the sentence of this court that you be placed on probation for a period of 1 year, 6 months as a 7411 status. In addition to the statutory terms of probation, you have the following special conditions. You must not use or possess alcoholic beverages or other intoxicants or enter any places that serve alcohol. You must comply with the requirements of alcohol testing as directed by the field agent. You must comply with the requirements of drug testing as directed by the field agent. You must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. You must complete outpatient or residential substance abuse treatment when referred by the field agent. You must complete a substance abuse assessment when referred by the field agent. You must perform 100 hours of community service as directed by the field agent. If you successfully complete that, court would reduce your fines and costs by $500. You must waive confidentiality and allow any treatment program that you are required to attend to disclose information to your field agent. You must not have any verbal, written, electronic, or physical contact without permission of the field agent with anyone you know to have a felony record. You must not change your residence unless you first obtain written permission from the field agent. You must have the object as a weapon. You must contact the supervising field agent no later than the first business day following your placement on probation. You must comply with all written and verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person or property without the need of a warrant if the field agent has reasonable cause to believe you have items which violate your conditions of probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. You must be in your approved residence between the hours of 11 p.m. and 5 a.m. unless excused by first obtaining written permission from the field agent. You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours a week. You must comply with DNA testing and pay a $60 fee, pay a $68 state cost, a crime victims assessment of $130, a supervision fee of $30 a month. It could be $60 a month if the Department of Corrections decides to put you on electronic monitoring. Court costs of $500, a fine of $500. And how much are you charging for attorney fees, Mr. Rowe?
Estimate of $500, Your Honor.
$500 for court-appointed attorney fees. Probation officers of this court or any other supervising agent may, pursuant to MCL 771.4, apprehend, detain, confine a probationer who is in violation of a probation condition or who is conducting himself inconsistent with the public good. You must not use or possess recreational marijuana or be with anyone you know to possess or use recreational marijuana. You're not allowed to purchase or use or possess anything that contains pseudoephedrine or ephedrine. Court has to impose license sanctions. Your license will be suspended for 1 year or 6 months. And restricted will be allowed after 30 days. Actually, we don't have to impose license sanctions since I'm giving you 7411, so your license won't be affected at all. You must set up a payment plan with the Clare County Clerk's Office within 30 days. Any questions, Mr. Ween, for this person or information?
No, sir.
Mr. Doran, can you please verify your telephone number, please?
I just got a new phone in the mail yesterday, so it's area code 989-424-742.
Could you say the last four, please?
7142.
989-424-7142, correct?
Correct.
And you still live at 625 Eola Road in Harrison?
Yes, sir.
Okay, I'll be contacting you later today with the specifics of your probation and when we're going to meet.
Okay, thank you.
Thank you.
You're all set, Mr. Doran.
Thank you, Your Honor. Wonderful day.
Can the person with the phone number ending in 615 identify for the court? Person with the phone number ending in 615, can you identify for the court?
Michael Pink.
Okay, Mr. Pink, thank you.
Thank you.
In the case of People versus Haley Christine Montoya, also identify for the record.
Morning, Your Honor, Mark Webb on behalf of the people.
Your Honor, Austin R. Rowe, appearing on behalf of Ms. Montoya.
You are Haley Christine Montoya?
Yes.
This was set for a pretrial. Has a pretrial form been forwarded to the court, Mr. Webb?
I believe I did that on Friday, Your Honor.
All right. Okay. Well, I didn't get it in the file yet.
I can,
Did you receive that, Mr. Rowe?
I received the pretrial, Your Honor.
Your Honor, I can print one off the library.
Well, just wait and let's see. Mr. Rowe, have you talked that over with your client?
Yeah, I've talked with my client, Your Honor. At this time, she doesn't accept the offer. She'd like to negotiate a little further. So I guess she either wants to put on a trial docket and maybe a status conference.
All right. This will continue on the trial docket. The court will sign the pretrial summary once it's brought to my attention. And we'll set a status conference about 6 weeks out and then a trial and a trial date after that. Anything else, Mr. Rowe?
No, Your Honor.
Anything else, Mr. Webb?
No, thank you, Your Honor.
All right. You're all set, Ms. Montoya.
Okay, thank you.
In the case of People versus Connor John McFalls, counsel identified for the record.
Your Honor, Austin R. Rowe appearing on behalf of Mr. McFalls.
Sherman's ice cream and people.
All right. Mr. McFalls, is he lodged?
That's it.
That's it. Oh,
Cool. Why do I have it in my book?
no. All right. This was just set as a status conference. Any movement in this case, Mr. Rowe? Anything you want to put on the record?
No, Your Honor.
All right. Ambersitis, if the people, anything further?
No, I see this as a probation violation, so.
Okay.
Sir, I just noticed, I went ahead and rechecked and he is lodged.
Okay. We're not gonna need him at this point. Do you want this set for a hearing date, Mr. Rowe?
Your Honor, could we set this for another status conference, please?
All right. About how far out? The next motion day or 2 motion days out?
2 motion days out, Your Honor.
All right. We'll set this for another status conference about 2 motion days out. We don't need Mr. McFalls.
Who is that? Who is that?
The next one, she is Erica Sue Johnson.
In the case of People versus Erica Sue Jensen, counsel identify for the record, please.
Morning, Your Honor. Mark Webb on behalf of the people.
Your Honor, Austin Rowe on behalf of Ms. Jensen.
And you are Erica Sue Jensen?
Yes, sir.
This was just set as a status conference. We have a final pretrial scheduled for September 28th. Is there anything you want to put on the record today, Mr. Rowe?
Your Honor, as far as putting on the record, I'd ask the court if we could do another status conference because the jail had problems with the internet. It's been difficult to call over there. I've not been able to consult with Ms. Jensen, so we're asking for another status.
I don't think we'll have time to put another status conference on before the 28th, so we'll just use the 28th at that time and go from there. All right?
All right, Your Honor.
Okay. You're all set, Ms. Jensen. Your name, sir?
Chaston.
All right. On the cases of the People versus Stephen Allen Chaston.
Your
Counselor,
Honor, sorry.
go ahead.
I was just gonna make my appearance here. Austin R. Rowe, appearing on behalf of Mr. Chastain.
All right. You are Stephen Allen Cheston?
Yes.
All right, this was just set as a status conference in two cases. Case number 21-006665-FH, and the case from which he's on probation for 19-006180-FH.
Well, Your Honor, we're still trying to work toward a global resolution on this. I think Mr. Chastain would be interested in the new felony case. That's in this case, the 21-665FH. He'd be interested in accepting the offer in that one, but he really wants to know what's going to happen with his probation violation. I've tried to contact his agent, haven't got anything back as so far currently as an offer or anything. So perhaps we could set this out again, Your Honor, for a status conference.
Mr. McConnell is the probation agent. Is there anything, Mr. Ween, in his file of any recommendation as to what should occur if he pleads to the probation violation?
No recommendation at this time, Your Honor, due to the pending felony case, and I understand that they're trying to do a global agreement. I think the issue is the amount of jail credit that Mr. Chastain has, 461 days, according to Agent McConnell. That obviously causes dilemmas for us with regards to what we can recommend. Basically, with that kind of jail credit, it leaves three options: wrap, prison, or unsuccessful discharge. So I believe that's probably what's causing the issues, Your Honor.
All right. The sentencing guidelines of the probation violation case were 12 to 30 months. So, all right, this is set for a final pretrial hearing on September 28th. So try and get a hold of Mr. McConnell and do what you can, Mr. Rowe, and we'll see you both on September 28th. All right. All right. For who? Okay. On the case of People versus Paul Edward Smith. Counsel, identify for the record, please.
Your Honor, Austin R. Rowe, appearing for Mr. Smith.
Besides appearing on behalf of people.
You are Paul Edward Smith.
Mr. Smith, you need to turn on your microphone.
Can you hear us, Mr. Smith?
Have a sign, Kelly, for him, so you turn on your audio. Yeah.
Well, this was set as a status conference. A pretrial summary has been forwarded to the court. Have you received that, Mr. Rowe?
Your Honor, I've received the summons.
All right. Have you had an opportunity to talk it over with your client?
Your Honor, I don't think I've had an opportunity to talk it over with my client. He's been in rehab, and I think this is maybe the first contact I've had with him since that time.
Court is signing the final, the pretrial summary. What we'll do is we'll put this on the trial docket. We'll set a status conference and a final pretrial hearing, and then the trial date. All right?
All right.
Since we're having trouble with him. And if you get in contact with Mr. Smith, maybe the best thing for him. You are Paul Edward Smith? Can you hear us?
I can hear you.
All right. We just filled out a pretrial summary. Get in touch with Mr. Rowe and talk about what the pretrial summary says. And we'll set this for another court date, a status conference, a final pretrial, and a trial date. All right?
Okay, will the next court be on Zoom also?
If you got a good connection, but today you don't have a very good connection, so I would, if that's all the better the connection is, then I probably want it to be in person. All right?
Okay.
Your
I think I got it figured out. I think I had it on mute.
Okay, you must.
That's why I was getting a connection.
All right. Make sure you get in touch with Mr. Rowe, that he has a good phone number for you.
Your Honor, may I ask Mr. Smith what his phone number is? Mr. Smith?
Smith is still there?
Looks like he's on mute, Your Honor. I'll try to find it later on, Your Honor. Thank you.
All right.
I'll try to get it from him.
Mr. Pink, can you hear the court?
Yes.
Thank you.
Calling the case of People versus Michael Stephen Pink. Will the attorneys put their appearance on the record?
Your Honor, Austin R. Rowe appearing for Mr. Pink.
People.
And you are Michael Stephen Pink?
Yes, I am.
And this was set as a status conference. Anything to put on the record today, Mr. Rowe?
No, Your Honor.
All right, we have a final pretrial scheduled for September 28th. And I think I'll require the defendant and the attorney to be present in the courtroom on that date. Anything else from any party?
No, Your Honor.
No.
All right, you're all set, Mr. Pink. You can sign off.
Thank you.
I believe that takes care of all your cases today, Mr. Rowe.
Thank you, Your Honor. Have a good day.
You too. You have Mr. Melton on? Okay. Aaron's in the jail?
He should be, the jail should be.
Okay.
Your Honor, I don't believe you need me present for the next motion, correct?
Probably not, unless he please.
I'll stick around then.
I'm sure he's gonna plead, but not the kind of plead we think. There'll be a lot of pleading going on.
All right. Calling the cases of the People versus Eric Danya Heron. Counsel identify for the record, please.
That's for him, people.
John Melton for Mr. Heron.
Mr. Heron is present, just the video's off.
Okay. And you are Eric Danya Heron?
Yes.
All right. This is set for a motion to revoke bond. You may proceed, Ms. Ambrositis.
Thank you, Your Honor. I'm just trying to pull it up, so I have it in front of me. So, Your Honor, according to our motion to revoke bond, the defendants
Bond in file 21-006585 FH was reduced to 300,000 cash surety or 10% after he's guilty in his two companion files, 2139 FH and 216540 FH. And on June 29th of 2021, he entered pleas of guilty in those two latter mentioned files. Sentences for both of those files were scheduled for September 7th of 2021. Bond in those two files were reduced to a PR bond with a GPS tether requirement upon entrance of his plea. On August 9th, we charged the defendant with home invasion, first degree assault with intent to do great bodily harm, felon in possession of ammunition, and felon in possession of a weapon as a habitual third offender. Based upon that, the facts and circumstances of that instance and all of the other circumstances that surrounded the resolutions as they stood in those cases that were mentioned, the defendant has proven that he's a danger to himself. He's now clearly a danger to his 17-year-old son because he's including him now in his criminal behavior. And he's a danger to the general public. We ask the court forfeit and cancel his bond on all three pending files and establish new bond sufficient enough to ensure that he can comply with the laws of the United States, the state of Michigan, and that the public is sufficiently protected. And in our bond motion, we ask that in 21-6585 FH, the bond be set no less than 500,000 cash surety only. That the PR bond in file 21-6539 be canceled, new bond established in the amount of 100,000 cash or surety only. That the PR bond in file 21-6540 FH be canceled and new bond be established in the amount of 100,000 cash or surety only. But if the court wants to establish bond on all three cases under one bond document, we ask that the bond be set no less than 700,000 cash surety only. Thank you.
Mr. Melton?
Your Honor, Mr. Heron has a new case, and it's my understanding that he's not going to be able to post bond in that new case. So, given our plea agreement on the two of these files, he would have to do a certain amount of jail time. So I think it is probably in his best interest, if he's not going to be able to bond out on the new case, to revoke his bond so we can get jail credits. Otherwise, he wouldn't be able to get jail credits toward those cases. What I found out this morning, though, Judge, is that the bond was completely posted by Eric's, Mr. Heron's elderly mother. And I was hoping that the court would consider, based on this information I received, that would consider not forfeiting the bond so that so the financial catastrophe doesn't fall on Mr. Heron's mother, who I think the court knows was acting in good faith. Pursuing some conversations that we've had, she was acting in good faith in posting the bond. So I think it is probably in Mr. Heron's interest at this point, if he can't post on a new case, to get the jail credits and revoke his bond, but ask the court to consider not forfeiting the bond so the financial loss doesn't fall on Mr. Heron's elderly mother.
Any rebuttal, Ms. Mercedes?
You know what? She knew what she was getting into. He knew what she was putting her into. And if he was that worried about his mother having a financial loss, he certainly wouldn't have committed the crime that he did when he was out on bond. So I think it should be forfeited.
Can I reply to that briefly?
You may.
We don't really know at this point, Mr. Heron, as far as the new charge, he's presumed innocent. We don't know if he's really committed a crime. I know the prosecutor doesn't have to maybe assume that he's innocent, but I think with all due respect, the court does, and we should maintain the presumption of innocence, not presume that he's committed a crime in this case. But the fact is, he can't make bond in the new case, so he should be getting credits.
All three bonds will be canceled. New bonds would be set at $250,000 cash surety in all three files. And the court will hold under advisement whether or not the court should forfeit the bonds until make a decision at the time of sentencing in these cases, in the two cases anyways.
Just a clarification, does $250,000 total or $250,000 on each file?
Each file.
Each file, okay.
And then, let's see. We have sentencing set for September 27th in two of the cases, so be prepared to argue regarding forfeiture at that time. All right?
Okay, thank you, Judge.
All right. You're all set, Mr. Herring.
Thank you.
Yeah.
And we're in recess.
All rise.
Hey, Peg.
Did you bring your judgment of divorce?
All right. 55th Circuit Court is now in session. Roy G. Meek presiding.
May be seated. In the case of Tina Brahman versus Paul Brahman, please come up to the tables. Have a seat. You both raise your right hands. Be sworn.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth to help you God? I do.
You are Tina?
Yes.
You're Paul?
Yes, sir.
Tina, is everything you wrote in your complaint true?
Yes.
You're a resident of the state of Michigan at least 180 days before filing the complaint?
Yes.
And a resident of Clare County at least 10 days before filing the complaint?
Yes.
You stated that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed. There remains no reasonable likelihood that the marriage can be preserved. Was that true then?
Yes.
Is it true today?
Yes.
Are there any minor children from this marriage?
No.
Are you currently pregnant?
No.
And you're asking that your last name of Wright be restored?
Yes.
Is that for any fraudulent purpose?
No.
And you're not asking for any spousal support, is that correct?
Correct.
You understand if you're not awarded spousal support at this time, you're forever barred from receiving it.
Correct.
And you're just asking that each party be awarded the personal property in their possession?
Correct.
And that each party be awarded whatever retirement benefits they may have in their own name?
Correct.
And you have some real estate that's jointly owned?
No.
No? Is the marital home at 11475 East Cranberry Lake Road?
That's mine.
It was in your name before the marriage?
Correct.
You're retaining it.
Correct.
And that's the legal description that's put on this paper?
Yes.
And Paul was never added to the deed?
No, he was not.
Anything else the court should know?
Not that I'm aware of.
everything that she answered to, the call to questions?
Yes, Your Honor.
Any dispute with any of those answers that she gave?
No, sir.
And you're not asking for any spousal support?
No.
I understand if you're not awarded spousal support, you're forever barred from receiving spousal support? And you're in agreement with the proposed settlement, is that correct? From the proofs that have been presented, it appears there has been a breakdown on the marriage relationship to the extent that the objects of matrimony have been destroyed. There remains no reasonable likelihood that the marriage can be preserved. The divorce shall be granted. Neither party is awarded spousal support. Marital home is awarded to the plaintiff. Each party is awarded the personal property in their possession. Plaintiff's last name of right is restored. Court is signing the judgment. Judgment is not final until it's recorded in the clerk's office. If you're going to follow the clerk back to the office, she'll give you 2 copies of the judgment.
All right.
Coming right out.
Will be shortly.
Might as well stand up now.
Right.
All right. 55th Circuit Court is now in session. Honorable Roy G. Meek presiding.
You may be seated. Calling case of Peggy Joan Richards versus Maynard W. Richards. Counsel identify for the record, please.
Good afternoon, Your Honor. Julia Basuli appearing on behalf of the plaintiff Peggy Duval, but I'm not sure if she is here today. Well, she is here today. Okay, well, she is appearing here today.
Thank you. Attorney Kimberly King, Gower Law, on behalf of Maynard Richards.
All right, and we have Peggy Richards on the Zoom.
Yeah.
Ms. Richards, are you there? Okay. You are Peggy Richards?
Yeah.
All right. Did we expect Maynard Richards to appear? Anybody?
No, Your Honor.
All right. It's plaintiff's counsel's motion to withdraw. You may proceed.
Yes, Your Honor. Actually, I was terminated by the client via text message on July the 9th. I had given the client an opportunity to do an order withdrawal, to which she didn't respond, sent that via email, and she never responded. So we filed this motion for withdrawal after I was terminated by the client, Your Honor.
All right. Ms. Richards, do you wish to say anything?
I was told by my attorney, Hector Citron, I didn't have to sign that paper.
So no objection to her withdrawing?
No. No.
Said no objection to her withdrawing from representing you at this time or in the future?
No.
All right. Court will sign an order upon presentation. I don't see one in the file, so send one in.
Your Honor,
Okay, I did attach it to my motion, Your Honor, as Exhibit A, but I can resend it. Thank you.
All right,
Your Honor,
we'll
if
look-
you can inquire into Mrs. Richards' current mailing address. I'm gonna have to file a motion to show cause. I need to be able to present it to her properly.
All right. Ms. Richards, what is your current address?
14 Hemlock Circle Track, Ocala, Florida. 34472.
Your Honor, I'm sorry, I did not catch that.
The zip code or what, or the whole thing?
The whole thing, it's coming up muffled on my end.
All right, could you repeat that, Ms. Richards?
Okay, 14 Hemlock Circle Track, Ocala, Florida, 34472.
I got it this time, Your Honor.
All right. The court has found the order allowing plaintiff's counsel to withdraw. The court is signing it.
Thank you, Your Honor.
Anything further from anybody else?
No, Your
Nothing
Honor.
further?
No, Your
All
Honor.
right.
No,
You're all
thank you.
set?
Thank you, Your
You're
Honor.
all
Have a
set?
great
You
day.
can sign off.
Thank you, Judge.
Thank you.
To the people of the state of Michigan versus certain real estate and other property. Mr. Webb, your appearance.
Good afternoon, Your Honor. Mark Webb on behalf of the people and plaintiff.
And there's nobody in the waiting room?
Is the attorney for your last case and somebody emailed me?
This is a motion for entry of default judgment. You may proceed, Mr. Webb.
Thank you, Your Honor. I'll mostly rely on the motion itself. Back in November 2019, Ms. McLaughlin was personally served with a summons and complaint for forfeiture that accompanied a drug case. She's presently in the Michigan Department of Corrections. She never filed an answer within the timelines and then not filed an answer ever. So I'd ask for an entry of default judgment, and I would prepare that order.
All right. There was a writ of habeas corpus in the file for Ms. McLaughlin to appear today. Present via Zoom. She's in the Women's Huron Valley Corrections Facility. Apparently there's been some problem with that, but she's not appeared. The court will grant the judgment and sign the order. I'll just submit it under a 7-day rule of the notice to Ms. McLaughlin.
Thank you.
That way. We're in recess.
All right.
Hey, buddy.
All right, 55th Circuit Court's now in session. The Honorable Roy J. Meek presiding.
You may be seated. In the case of Melody Courtney versus Edward Schnook, Roy Adams, David Cribble, their heirs, successor, and assigns, and all who might have an interest, claim an interest in plaintiff's real property. Counsel, identify for the record, please.
Good afternoon, Your Honor. J.J. Klaus representing Melody Courtney.
Melody Courtney here.
All right. And you may proceed. It's your motion, Mr. Klaus.
Your Honor, this is really quite just a formal process that we need to get through. We've published according to the court's publication order. We've received no response. We're asking that the court enter a default against the defendants. We also have submitted a proposed order for the court to enter an order to quiet title, and we ask that the court enter that order today. Would you have any questions, or do you need any additional testimony?
Any additional? Just looking at the file to make sure that we have proof of service. We have the default entry, so it usually means we have the proof of service in the file. Here's we do have the publication. Court will sign the order.
Thank you, Your Honor.
Anything further?
No, Your Honor.
All right.
Well, they said.
What'd you say?
They'll send me a copy and I'll have to get back with the clerk and get a certified true copy in order to have that recorded. I don't know which is the best way to do it, whether or not I could just ask for one be sent to me and then we could get it recorded and I could submit the certification.
You can talk to the clerk. I'm in recess.
All right.
Thank you, Your Honor. All right, Melody, you're all set.
Thank you.
Mr. Klaus, you'll get a copy if you want to do an online to all paid for $12 to notify it, or you can just send a check for $12 and whatever the filing fee is, and we'll take it down there for you.
Okay, I will, I'll do that. I'll send that out today and ask for a certified true copy of that be recorded in the land records. And it's $12 for the certification?
And I'm not sure if you want to include the fee for the other side to file it. You would have to check with them and you can just write one check.
Okay.
And we'll take the certified copy down there for you.
That is so convenient. Thank you so much.
You're welcome.
Sure, follow up with everybody and see what's the most convenient way to do it. With this, usually I'd be there and I could pick it up and get it taken care of.
I know.
Thank you.
You're welcome. Have a good day.
Bye.
Miss Courtney, you can log off as well if you'd like.
Bye.
All right. 55th Circuit Court is now in session. The Honorable Roy G. Meek presiding.
You may be seated. In the case of Cedar Shores Campground Condominium Association versus Kevin Lynn Pancoast and Joetta Pancoast, counsel identified for the record, please.
Your Honor, Isaac Post for Cedar Shores Campground Condominium Association.
Maureen Van Hoven for the purchasers who are an interested party in this matter, Your Honor.
That's the Verbecks.
Yes, Your Honor.
Anybody else on Zoom here today?
My client is also attending, Your Honor.
All right. We're hearing a couple of motions. One is a motion for alternate service. Was that already granted? And a motion to declare the real site condominium abandoned and declare all personal property remaining on the underlying real site condominium abandoned and shorten the redemption period. They're your motions. Ms. Van Hoven, you may proceed.
Thank you, Your Honor. Yes, we would like to serve a motion to shorten the redemption period. The problem is that we know that both Pancos are deceased, and this original foreclosure action was served via publication. And in order to dot all our I's and cross all our T's, we would like to serve that motion by alternative service as well. And what I wondered if the court would allow us to send it to the last known address, post it on the property, and then we wanted to record a notice of hearing with the Register of Deeds, because anybody who is seeking information about potentially redeeming this property would do a title search or would check with the Register of Deeds. And that might be a very good way to give any potential person who was going to redeem notice that there was going to be a motion. So if we could set the motion to shorten out maybe 3 weeks, that would give me time to put the notice of hearing into a recordable format, do the posting, mail it to the address or the last known address. And then in 3 weeks, we could have the motion to abandon where the judge could make findings.
Any objection, Mr. Post?
Your Honor, we take no position regarding this. I don't believe that whatever happens regarding redemption period affects my client, so we do not take a position one way or the other.
All right. Court will grant a motion for alternate service and we'll sign an order upon presentation. I don't see one in the file, so you'll have to get us one to sign.
We'll get you one, Your Honor. Thank you.
All right. Anything further from anybody?
No, Your Honor.
We're in recess.
All right.
You're all set, everybody.
Okay, Maureen, before you sign off,
Yes.
I just found, I was looking for this in my file, Samantha Pancoast. She